Thank you, folks. Please be seated. The next case for hearing is the Catawba Indian Nation versus the state of South Carolina. And prior to hearing argument on the case, let me make a couple of announcements. Chief Justice Toll is recused in this case, and sitting in her stead will be Acting Associate Justice Keith Kelly, a circuit judge from Spartanburg, South Carolina, who is to my immediate right. I would also tell everyone that this case has garnered a great deal of interest, but it is also our class action program. And I think that you lawyers are all familiar with the class action program, where we have students from various schools around the state who are familiar with the briefs in the case, have studied the case to a certain degree, and will attend the oral argument. This is also going out by a live feed to other students throughout the state as well. These particular students who are in court today are from River Bluff High School, and the teacher is Meg Huggins. Ms. Huggins, are you here? Would you please stand up? And we're delighted to have all of the students from River Bluff.
They are. We're all part of the Law and Global Policy Center at River Bluff High School.
And that is the Center for Law and Global Policy Development at this new state-of-the-art high school in Lexington District 1. We're delighted to have you with us. And at the end, lawyers, please remain in place because we entertain questions from the students with regard to your views on certain things, certainly not the case, which you will articulate during your course of your arguments. With that, Mr. Wilkins, you ready?
Yes, Your Honor.
Yes, sir.
Mr. Acting Chief Justice and members of the court, my name is Billy Wilkins, and along with Kirsten Small at council table, we represent the appellant.
Mr. Wilkins, may I interrupt you before you get started? And hopefully you don't mind.
I don't mind.
Let's cut to the chase here. Does Catawba, the old Catawba case, control this situation here?
Absolutely not.
And tell us why not, please, sir.
Well, because in that case, the resolution of this appeal begins with the reading of two documents. One is the settlement agreement, which I'm sure the court is aware, entered into between the Catawba Nation and the state of South Carolina, ratified and codified by the United States Congress and our General Assembly, and the Gambling Cruise Act enacted by the General Assembly in the year 2005. This is the first time this court has ever been asked to read these two documents in conjunction with one another. The case that you referred to, Your Honor, dealt with the subsection 2710 of Title 1221-2710, which was a ban on video poker. This has got nothing to do with that statute. And the case that you referred to had nothing to do with the Gambling Cruise Act that was enacted into law at Section 3-11-100. So we're dealing with two different sections and the application of those sections to the settlement agreement. In the first case that you talked about, it was the Catawba's position that the ban on video poker did not apply to its reservation. This case, the action before the circuit court and the subsequent declaratory judgment action that was brought, asked this court to declare whether or not the Gambling Cruise Act applied to the settlement agreement. And we say it certainly does. Now, the circuit court adopted verbatim the position that the Attorney General took. And because the Attorney General got it wrong, so did the circuit court. In its order, time and time again, the circuit judge says that the Catawba Nation should be treated like everyone else, and I quote, everyone else in South Carolina. The court went even so far at the urging of the Attorney General to say if the appellate prevails in this case, then everyone else in South Carolina can offer video poker. This is an empty, hollow, incorrect statement with no basis in fact or law. All that will happen if the appellate prevails in this case is that the Catawba Nation on its reservation will be able to offer the same type of gambling activity that the Gambling Cruise Act authorizes to ships to nowhere.
I'll assume you're speaking to that section of the settlement agreement that says that they may play devices to the same extent that the device is authorized by the state.
Section 16.8.
Now, that language, to the same extent, how do you define that?
Scope, range of operation. That's what Black's Law Dictionary defines it. So whatever the cruise to nowhere statute allows, the same thing, no more, no less, is allowed on the federal territorial lands known as the Catawba Reservation.
So in your view, then, there is no difference between one being ocean going or on water and the reservation being land?
There's absolutely no difference.
So
The statute, that if you read it, that's what the Attorney General is going to argue to you, that we need to change the agreement just a little bit and say, to the same extent authorized by law within the state. Well, the agreement doesn't say that. The words are so important. The agreement made between the Catawbas and the state of South Carolina, recognized by the Congress and our General Assembly, does not have any type of geographic component to it. It says authorized by law. And wherever the state authorizes gambling, to the same extent, the Catawbas are allowed to do the same thing on their federal territorial lands, known as their reservation.
Is the phrase "to the same extent" in this context ambiguous or unambiguous?
Well, I would like to say that it's not ambiguous. It is unambiguous because same extent, if you look to the dictionary, and this court in the first Catawba case went to Black's Dictionary to decide what the word permit means. We can do the same thing here, I would suggest. But let me remind the court something. Every time a statute or an agreement, a treaty, anything dealing with Native Americans, the law is clear that these documents should be construed liberally in favor of Native Americans and any ambiguity resolved in the favor of Native Americans. Now, the Attorney General took the position below, and the Circuit Court adopted that position, that this court rejected that principle of statutory construction in the first Catawba case. They've now abandoned that position, but nevertheless, every court, every state court, every federal court, United States Supreme Court, have always used this principle of statutory construction and guided this decision for the last 200 years. So I say to this court, if this court says it's not ambiguous, nothing's ambiguous, then the appellant prevails. If the court says, well, reading these two documents, that is the settlement agreement and the Gambling Cruise Act together, there may be some ambiguity there. Then it must be resolved in favor of the appellants, and therefore the appellants prevail. So either way, it is our position, Your Honor, that the appellants are going to win. I don't think it's ambiguous, but if it is, we're still going to win, because you have to resolve those ambiguities in favor of Native Americans, and that's been our principle of law that's guided every court in this country for, as I say, 200 years.
Mr. Wilkins, if I could switch gears, I want to ask about the Johnson Act.
Yes.
The Johnson Act apparently was a vehicle for delegation of authority to the states. The state, in turn, delegated the authority under the Gambling Cruise Act to counties. But states were not mandated to pass legislation, I do not believe, in response to the Johnson Act. You with me so far?
Yes, sir.
If the state had remained silent legislatively and had not passed any act, would these cruises to nowhere be legal or illegal?
Legal.
Why wouldn't the Gambling Cruise Act, therefore, not be permission to grant it?
Well, you see, this court, as I'm sure the court well knows, earlier this court had issued an opinion that there was no law, existing statute on the books that prohibited cruises to nowhere. That was about 2001, as I recall, and then in 2005...
Talking about a start answer?
Sir?
Start answer case?
Yes. I'm sure the court's very familiar with that. But in any event, 2005, well, 2002, here comes the Johnson Act. It did just what Your Honor says. 2005, the General Assembly passes a Gambling Cruise Act. And what it did was, it said, okay, we recognize we're going to continue to allow authorized cruise acts under certain regulations. and the state regulated what's going to happen. And one of the regulations was, it said that every operator must report to the State Department of Revenue every 30 days the profits and losses of every machine used on a cruise to nowhere during that 30-day period. And then it delegated to the coastal governing bodies of the coastal counties the authority, and I quote, to regulate or prohibit. And of course it was not prohibited, and if you regulate, which the counties have done, as North Charleston has done, then you regulate, you authorize. So, I mean, that's, to me, it looks pretty clear that this state, through one method or another, has authorized cruises to nowhere, which allows gambling on federal territorial waters. And as the Casino Ventures case, I believe it's entitled, said, this is a delegation of police power from the federal government to the state power, power to regulate. We have it, we've used it. And as a result of that, to the same extent, allowed on federal territorial waters, to that same extent, the same operation, the same activity, video poker, is allowed on the federal territorial lands where the Catawba Reservation is located.
Well, then, let me ask you this question. We might switch gears.
All right.
There's an allegation that this particular action is precluded by res judicata or collateral estoppel. Would you address that, please, sir?
Yes, sir. Well, first of all, it's not. Of course, the Robinson case from the South Carolina Court of Appeals clearly says that when one seeks the first action seeks the declaratory relief, res judicata is only a bar to matters which were actually litigated, not those that could have been litigated. Now, what the Attorney General has done in its brief, all of the cases it cites, except for two, do not even deal with declaratory judgments. They just go with the same boilerplate language that says, if the first action was litigated or could have been litigated, then res judicata bars in the second action. But that's not true for declaratory judgment actions. The only two that they mention is one is the, the Pye versus Aycock case, and that was a case where a declaratory judgment was sought in federal district court. A jury was impaneled and made certain findings of fact dealing with Aycock's liability for assault on Pye, Mr. Pye. And when the case was brought in state court seeking damages, the court said, well, the findings of fact in that first case are conclusive in this case. Well, that's got nothing to do with this case. There are no findings of fact in the first Declaratory Judgment Act. It was purely, simply a question of law. And the other case, the only other case that mentions declaratory judgment is from Texas, the Ortega case. And I just suggest to the court, if you read that case, you'll see it has absolutely no application to what we're talking about today. So the declaratory judgment rule, and I'll commend to the court the case called the Robinson case versus Hartwell, First Circuit case from Federal Court of Appeals, and it's really like a law review article.
Robinson v. who? Hartwell?
Hartwell. Hartford, the insurance company.
All right.
Yeah. But anyway, that's where the court there researched the law from all over the United States. Here's what the court said in the Robinson International versus Hartford. As to matters not declared, the parties are not so precluded. The vast majority of states have addressed this problem unapologetically, applying this rule. That is, if it's a DJ action, only things that were litigated in that DJ action are subject to res judicata bar and a subsequent action. And that's what we got here.
Thank you.
Thank you.
Mr. Jones,
Okay, please, the court, Sonny Jones, the State Attorney General's office, and at the council table with me is Solicitor General Bob Cook. We're here before the court representing the respondents, the state, and Chief Keys. Your Honor, I have, Justices, I have outlined my argument to set forth in a brief, and have some notes I wanted to present to you in a chronological order. But I thought it best to pick up on the res judicata and the collateral estoppel issue.
Well, okay, yeah, go ahead and talk about your issue preclusion cases, but, you know, just speaking strictly for myself, and don't talk about them too long.
Okay.
Okay.
Well, it's our position that the collateral estoppel and res judicata apply in this case. What is missed in the arguments by the appellant is the purpose of the bar for res judicata and a declaratory judgment case. Citing, and this is a good review, my friend Billy Wilkins offered a case up. In the briefs of the Catawba tribe, at pages 2 and 3, the circuit judge order, court order, page 13, in our brief on page 22, is cited restatement of second of judgment, section 33. And there they go into why this bar with a with res judicata on collateral estoppel, but it's still a bar if the same subject matter, but only as if to matters that could be brought. And the court talks about the fact that in the declaratory, the purpose is to reduce litigation and conserve judicial resources by bringing one issue before the court. It says res judicata has some of the same purposes. It is to relieve parties of cost of being litigated again, conserve judicial resources, and prevent inconsistent decisions and encourage reliance on adjudication.
But Mr. Wilkins' argument is that's true for all other matters that you might bring, but not in a DJ action, and that is different.
Well, in a DJ action, res judicata is a bar if the same parties, same issue comes to adjudication for a competent court. We say the same subject matter is at issue. The subject matter is the right for the Catawbas to have video poker and video gaming devices on their reservation. They got another legal theory they came up with. Now, going further, while we say that the bar for res judicata and declaratory judgment cases should not be, in this case, restrict additional legal arguments, is that the reason is to prevent in a declaratory judgment action a person moving for declaratory judgment action to have to present all their arguments. So it'd be a full-scale litigation. Well, you look back at 2007, that's what we had. We had a full-scale litigation. We didn't have one issue. We had 4 issues on the issue of whether the Catawbas could have the right to video poker on a reservation. If you look back at Catawba's decision, it was if video poker was banned in the county, that issue. The second one, the bingo language, is another issue the court had to address, and this court addressed that. The third, because it was a sovereign. The fourth, they had to consent to amendments. And there was another one about a bingo issue on entrance fees. So there was a full-scale litigation at the first one. They were represented, as you will see in the record, by Mr. Bender, who was there earlier on with the settlement, and one of the best law firms in this state and recognized nationally, Nelson Mullins. There was no holds barred in that first litigation. The record was voluminous. Also, you will note in that first litigation, which is important, they asked for coercive relief, which is when you ask for a relief for declaratory judgment, then you ask for coercive relief. They asked for a permanent injunction. You look at page 100 in the record. We included the tribes, the Catawba tribes, Catawba Nation's brief in their complaint in the first that matter. It asked for a permanent injunction. That flips everything, because number one, the purpose of judicial economy was not served. They had 4 issues plus the bingo issue, and this court addressed all of them. Secondly, they asked for coercive relief. And you look at the cases that I referred to in the Amsure sites, they talk about that. I have not reviewed the treatise in the case that Mr. Wilkins presented, but I'm sure it's going to be the same thing. So what we have here is we have the identical parties, the identical subject matter, the right for Catawbas to have gambling on their reservation, and an adjudication of that right. This court said on the contention of the Catawba Nation in the last case that to adopt their contention would lead to a plainly absurd result. I would contend to this court that today to adopt that the Gambling Cruise Act authorizes the tribe to have gambling machines on their reservation would be a violation of the legislative intent and lead to even a further plainly absurd result.
I was going to say, take it step by step. Why wouldn't the federal enactment allow possession if you will, on the reservation.
Well,
Possession. I'm talking about possession. I'm not talking about use, okay?
because the federal act, it was discussed earlier, was initiated by the Johnson Act. At that time, the Johnson Act it actually said that federal flag vessels could bring their machines inside the 3-mile range, and then take their flag vessels that were going from one spot to another spot, then out of state, not cruises to nowhere. They said, we're going to tell the state federal flag vessels can do that. Along the way, it said that we will allow you to control cruises to nowhere that start in your port and come back into your same place. Okay? Now, it's important that you look at the Casino Ventures case, because when you get into this thing about preemption, the Casino Ventures case pointed out that in Alaska, the Johnson Act said that we're going to tell Alaska that you have to allow, in the 3-mile limit, our passenger ships to gamble. So when you set the framework for the Johnson Act says, for South Carolina, we're going to say that our passenger vessels, federal flag passenger vessels, United States, can come within your waters, but they can't gamble. They go out to high seas, they can gamble. So it is permission outside the 3-mile limit. They authorize the covered up machines within the 3-mile limit. Then they said the states could do the same thing. Now, what the Catawba tribe is saying in this case,
It allowed the states to actually regulate the use of these machines past the 3-mile limit, did it not?
yes, sir. And in fact, what they said, and I think it was Justice Kittredge that said, the law has been in effect here, and this is another issue. At the time they presented their first case, this gets back to the Yeltsin case about the documents that people couldn't find at the beach as far as the land. A case decided, I believe, in 2012 that Justice McComas was the author of. Not only was the Gambling Cruise Act in effect in 2005, in June, when the complaint was filed in the first case in July of 2005, the right was already there from 2001 to start answering. Actually, the right was there from 1992.
Let me ask, I just want to put some pressure on your argument to find out where, in your judgment, the boundaries are in understanding the phrase to the same extent that the devices are authorized by state law.
I think, Your Honor,
And I have a question of, okay, that was not a question.
okay.
Assume the General Assembly passes a statute, keeps the overriding ban in place, that says we're going to allow counties along the coast in high tourist areas to opt out. And let's say they further say, well, counties or local governments with a population in excess of a certain amount. Thresholds that are beyond that the Catawba Nation would meet. If the state did that, could the Catawba Nation then invoke this and justifiably allow use and possession of these machines?
Without addressing whether that would be a wise move to take, Your Honor, the situation would be, that would be amendment, could be amendment considered in 2017. The Catawba Tribe case says, currently, under 12/21/2017, video poker or video gaming devices are illegal in South Carolina. It said that in the footnotes, specifically. And in the start answer
I'll
case,
try the question again. Assume the legislature passes a law and allows, let's just, one example, counties with a population threshold of 100,000 or greater, we give the option to allow these video gaming machines, but no county under 100,000 population.
that type of selective legislation could become under attack. Now,
In
if you're
that
saying,
situation, you wouldn't, I mean, you would agree on that situation, the Catawba Nation would clearly have the right to do the same thing.
the same extent is authorized by state
And
law.
Mr. Jones, we got dozens of valid statutes that have population thresholds, you
Yes.
know that.
Yes, sir. So the point would be, if it's within the territory of the state of South Carolina, and there's an amendment that would be in effect of 12/21/2017, then in effect, that we couldn't consider an amendment to state law. Catawba Tribe said in 2007 that currently, and the Gambling Cruise Act was in play at the time, and although I couldn't find a case, there may be a case out there, and Solicitor General could find a case in South Carolina that said that this court is aware of its early decisions. We did find a court in another jurisdiction that said when a court, like the Supreme Court here, makes a decision, it's aware of its earlier decisions. So I would think, even though it wasn't brought up, that this court was aware of the casino ventures.
But does it matter that, you're talking about Justice Burnett's
Yes, the Star Dancer case.
Star Dancer, but does it matter that the Gambling Cruise Act was not discussed at all in that case?
To me, it doesn't matter. I think the court was aware of it. It has no, I would say today, the answer for this court would be that to say that the Gambling Cruise Act allows gambling devices on the Catawba's reservation is a plainly absurd interpretation that this court cannot adopt. It's not the legislative intent. You can just look at the Gambling Cruise Act and also look back before 2000 when we had video.
Well, that gets to Justice Kittredge's question, what does to the same extent means?
The same extent means authorized by state law. What appears to be that counsel is saying for the tribe is if a device...
Differentiate between the two then.
Okay, I think his position is if a device is authorized, if it names a machine, then you can have it. To the same extent as authorized by state law, you have a statutory framework. Look back before 2000 when video poker was in South Carolina, there was a statutory framework. Although it might have been abused, there were limits on the number of machines. There were licensing, there were regulations. Look at what the tribe is saying as far as if the Gambling Cruise Act allows the tribe to have on a reservation. There are no restrictions. Mr. Wilkins mentioned they looked at volume, how much money you raised, and also I believe it's a passenger count. Does not address the number of machines, amount of machines, or whatever. So what he is asking this court to do, along with a plainly absurd ruling that I think based upon legislative intent, is to take 3 miles out in the high seas, bring it into the reservation, totally unregulated, casino-type gambling. If you would see, I believe, in the earlier pleas, I could be wrong on this, that were filed, they were going to open up a casino. They weren't going to have 4 machines in a certain area of a place. That's what their intent is. Their intent is casino. They want to go IGRA, Indian Game Regulatory Act, which we don't have here. And also, in an earlier decision in Florida, who has IGRA, in a Seminole case, 1993, the court went through this thing about allowing a certain type of gambling, and then they said, well, the tribe in that case said, well, wait a minute, you're allowing it in-state under IGRA, which is more liberal. It means you have to get together and negotiate, you have to get a conference and everything else. And the court says, wait a minute, this is outside the state, 3 miles outside the state. So it's not like we're coming up with this for the first time. It is common sense, number one, in our position. Number two, this court hit it dead on in the first one. We can't have a plainly absurd reading of the statute. There's no question that within the statute of the state, the Catawba tribe case, which says it, and the casino, in the Star Dancer case, that it says in a footnote in Star Dancer. We're not talking about in-state. So they're saying the same extent means if you get a machine legal 3 miles out or 50 miles out, the door is open for 50 million machines on the reservation, which is totally absurd. Because once again, the Gambling Cruise Act has no regulations on machines. This case, although it's interesting on the merits, res judicata and collateral estoppel, it hits it dead on. For the purpose of res judicata and collateral estoppel, number one, we say identity of the party, subject matter, a proper adjudication for a court of competent jurisdiction, which is this court. The same issues addressed and ruled on. Secondly, any issues that could be brought, the declaratory judgment bar does not apply. You read the cases. When they went 4 issues and they went coercive action, they passed the exception on the declaratory judgment with res judicata. They could have brought it in 2007 and 2005. They could have addressed it then, they didn't. It was around since 2001. It was around since 1992. Thank you very much.
Yes, sir.
Justice Kittredge, the answer to your question is a resounding yes. The language in the agreement between the state of South Carolina and the Catawba Nation is very, very important. In addition to a number of rights and privileges not enjoyed by anybody else in South Carolina, tax exemptions, their own constitution, their own court system, their own police force. They were given a very important right in section 16.8. This is the language: the Catawba Nation may permit on its reservation video poker or similar electronic play devices to the same extent that the devices are authorized by state law. It has no geographic limitation or boundary. What the state of South Carolina has done through the Gambling Cruise Act is to authorize gambling on federal territorial waters. I don't think there can be any question about that. And if that is the case, and pursuant to this agreement, the Catawba Nation is allowed to offer the same activity on its federal territorial land, known as the Catawba Reservation. Indeed, the agreement says this, something that Justice Kittredge alluded to: even if the county where the Catawba Reservation is located, through a local auction authority, banned video poker in the county, the agreement plainly says that it will still be allowed on the reservation if it was authorized by state law. The question is, what was authorized, not where it was authorized. Thank you.
Thank you, Mr. Wilkins. Thanks both counsel. At this time, we'd like to ask our students from River Bluff to, if you would, pose questions to members of the court or to counsel. You've heard an argument of a case by two of the most able appellate counsel in this state, and they've ably set forth their positions in the case. We're not going to get into questions that may go too far with regard to their views of the case or whatever, but you are at this time free to ask any questions that you wish of any member of the court or of counsel with regard to this matter. Ms. Huggins, you going to make somebody do this? Or?
I have a feeling they'll be really chatty. So. Okay,
well, good. Well,
okay.
Where's a hand to be raised among? Yes, sir. Please stand up and state your question.
This is just kind of an open question to really anybody. What is y'all's opinion on the affluenza defense case that was presented? I think it was in Texas, where the kid got off.
Because he was too affluent in the product of a rich family, and thus it was coddled and all of that. You know, without it's not really appropriate for judges to comment on matters that may possibly come before the court, but I believe that Justice Kittredge and all y'all, would y'all agree with me that that would be subject to a Lafluenza response? Anyone else? Yes, ma'am.
Why do you find that the appealing process is so important in our judicial system?
The what process?
The appellate process.
Well, let's start with Justice Beatty. Why is it, Justice Beatty?
Very, very important. We all are human. We make errors. No matter how hard we try to avoid that, we do all the background work, we do the study, but we make mistakes sometimes. And then there are matters, for instance, that come up with first impression. Both sides may have a good position on a particular issue, and one side loses. And that decision has not been made on that point before by a higher court, such as this court. And that's a good reason for the appellate process. No system of justice, in my opinion, should stop at any one level, ever.
Thank you, ma'am. Anyone else? Come on, I know that there's a fertile field of questions out there, please. Another hand, come on. Yes, sir, come on.
How do the attorneys prepare for a case like this?
Why don't you ask the attorneys, Mr. Wilkins? Mr. Wilkins and Mr. Jones, Ms. Wilkins, first address.
Well, what I do is I rely on my able assistant. But you really prepare a lot. There are a lot of cases to read. The Attorney General writes, we write a brief, they respond, we back and forth, we cite the same cases, we may give a different interpretation to them, but What we do preparing to come here today is to spend part of the last week thinking about nothing else but this moment that just passed. And I know that Mr. Jones does the same thing, because it's a concentrated effort that you have to because we were given only 15 minutes. And the court may extend that, but if they don't, we've got to get everything that we think is important before the court during this moment of time of oral argument. Sonny?
Yes, for an attorney in our position with the State Attorney General's office is a little different. We give the same focus that Billy Wilkins does, but we have less resources, and I think Judge Wilkins would admit to that. So we have distractions that we can't delegate to everybody else. So you got to learn to focus, and you got to learn to read all the cases. In our office, the Attorney General's office, we have a source, the Solicitor General, the first one in the state of South Carolina, Bob Cook, who's absolutely the top legal law person in the state, in my opinion. And I'm not the only person that says that. So we have that resource, and Bob has many other functions he has to do. So we take that resource, we read all the cases, we write out our arguments, we change our arguments as early as this morning, we make notes on our arguments, and then we don't even use the notes on the argument. If people in my group, I would say, you try to get, and I hate to turn my back on the court, you try to get a minute of your argument out. But since we're the respondent, Judge Wilkins, Billy Wilkins, he's a former judge, he dictated per the question from the court where we went. So it's almost like I just hand this back to somebody else. So that's why memorizing, I remember when I was a young person like you, which was not that long ago, when I made a speech in school, high school, I memorized it. And so you have to do like Billy Wilkins has learned, and of course the justices have learned, you got to talk it. And if you can get up and talk it and understand it, then coming up with a question from a different angle, like Justice Kittredge had a question that kind of throws you off a little bit, and you get back to what was his focus, because he asked it again. So you got to realize you're going to be a little bit nervous the first time in the batter's box today, not necessarily the first time ever, but you got to enjoy it. And you got to read the law and enjoy it. If you read the law and enjoy it, and understand your position, and have the support, you'll do fine. And the law is the best place. I finished engineering years ago. And now this is the best place to be in our office, the Attorney General's office, offers the best opportunity for that.
Thank you, Mr. Jones. And let me add to what flesh out what Mr. Jones said. Not only Mr. Wilkins a former judge, he's a former chief judge of the Fourth Circuit Court of Appeals, which is a level in the appellate process just below the United States Supreme Court. And we have Solicitor General Cook over here, who we do not require to wear a morning coat as he would if he were the Solicitor General of the United States. But you've got some really heavy hitters in front of you. Any other question? Oh, excuse me, Justice Bailey.
Justice Broconis, what might we add to the preparation for taking up one of these cases? We talked about how the lawyers prepare, but would you talk about how the justices prepare? Because we do as much reading if not more, than the lawyers involved in this case, as well as our law clerks. And the reason why they don't get to use their notes is because we're that prepared. We've already read it all, and we have questions that we need to answer.
I'm going to ask Justice Kittredge to cover that, because this court does meet as what is known as a hot panel. And Justice Kittredge, would you like to address that?
Well, I answer that not only in the context of this case, but we're hearing 9 different cases this week. We heard 2 earlier this morning on entirely different areas of law. So just as these excellent attorneys have to spend untold hours in preparation, we as judges, accompanied by terrific staffs, young lawyers who work for us and help guide us, must spend a lot of time preparing. And totally different areas of law. It can be something out in left field and you go to right field. There might be no commonality to it all, but you have to study very hard and diligently to understand each case, because you never can forget that each case is so important to that litigant. And I remember when I first became a judge 23 years ago, I was reminded of that. And I try to remind myself that every day. You don't want to have a mentality that you're on an assembly line, just moving cases. Every case is so important to that litigant. That might be that litigant's only day in court in their life. It is going to be the most important thing in that litigant's life. And we owe it to each litigant to give each case its due and diligently prepare, honestly approach the case and do the best we can to follow the law. And it's easy to say that, sometimes very hard to do in difficult cases.
And thank you, Justice Kittredge. We have time probably for one or two more questions, if you would. Anybody else? Yes, ma'am.
What are your views on tort reform?
Let Justice Hearn answer that question, if she wants to.
Thanks for giving me the easy one, Chief. Well, my view is that it's a matter for the General Assembly, for the legislature, and like so many laws that are passed, it honestly, as a judge, doesn't matter whether I agree with it or not. I take an oath, as we all do, to uphold the law. And there's certain, we have, I'm sure you're aware that we have a separation of powers principle that permeates our government. And as the role of the judiciary is really not to make the law, it is to interpret and to apply the law. And I try to do that. So my views on tort reform are as irrelevant as my views on the death penalty, because I'm bound to follow the law.
Thank you. And one more question. I think we have probably time for one more, if anyone wishes to pose one. I want to give Judge Kelly, Acting Associate Justice Kelly, an opportunity to answer. Anybody? Yes, ma'am.
So I tried to become judges or serve in the Supreme Court instead of lawyers, or were y'all lawyers?
I'm sorry, I didn't.
Were y'all lawyers, and why did y'all decide to become judges on the Supreme Court?
Were we lawyers before we became judges? Some
Yes.
say no, but I'll let Judge Kelly answer that question.
Thank you, Chief. Yes, we were lawyers before we came to the court, to the bench, and of course I'm a circuit court judge here in South Carolina, and sitting today by special designation due to a chief conflicting herself out. But I myself practiced for 25 years in the courts of this state prior to taking the bench.
Thank you, ma'am. Thank you so much for your attendance here, and our court is now in recess.